state.
Thank you, Your Honor.
The defense and the state will then be required at the end of the case to declare under the penalty of perjury that they returned their copy and all other copies to the court so that those copies can be destroyed.
Yes, Your Honor.
Okay?
Thank you, Your Honor.
Thank you.
Your Honor.
Oh, and Your Honor, just to make the record clear, I also forwarded Ms. Coe's motion to the victim. Since I don't represent the victim, I wanted to make sure she had an opportunity, if she wanted,
Sure.
to hire her own attorney. So I wanted to make sure that all stakeholders have been notified and that that's clear on the record.
Good enough. Thank you.
Thank you.
Thank you, Your Honor.
If we could do Adonis Brown next, please.
All right.
I just caught one sit down there. I thought it was like, yeah.
Hey, did you ever get your copies?
No. Okay, I'll make a copy later. It's okay.
No, I think they're sitting on the copy machine.
Oh, me.
State versus Adonis Brown, 15-1-048602, comes before the court this morning for plea sentence.
Your Honor, Mr. Tolson just stepped out to get the documents, a copy for his client, so
Okay.
I think he'll be right back in. Good morning, Your Honor. Jared Osser on behalf of the state. Mr. Brown is present in custody, represented by Mr. Tolson. You're correct, this is on for a plea and sentence. I've handed forward to the court a statement of defendant on plea of guilty in count 1, manslaughter in the second degree with a firearm sentence enhancement. Count 2, unlawful possession of a firearm in the first degree. Mr. Tolson prepared this document last night, emailed it to me. We met this morning. It looks appropriate. I believe we're ready to proceed. Mr. Tolson is present as well. Thank you.
Okay. Thank you. Mr. Tolson.
Good morning, Your Honor. For the record, Les Poles on behalf of Mr. Brown. Mr. Brown is 17 years old. He has not yet completed high school. I have prepared the statement of defendant on plea of guilty. I went over it with him last night. He is pleading guilty to the original charges. Manslaughter in the second degree with firearm enhancement. Count 2, unlawful possession of a firearm enhancement. I've discussed with him the elements of each crime and what the state would need to prove if he were to go to trial in this matter. I've discussed with Mr. Brown his constitutional rights and explained to him the concept of the jury and what his rights would be as an adult in the adult system. He's indicated to me he fully understands all of that, including the fact that he's given him his rights to an appeal and he's given him his right to a jury trial. I've discussed with him what the his offender score in this case is and how that is calculated. By my calculation, on the manslaughter charge, he has an offender score of 5 because there's a multiplier. On the offender score for the unlawful possession of a firearm charge, his offender score is 4 because there are no multipliers. He is facing 18 months community custody. He's got a standard range of 46 to 61 months on the manslaughter charge, plus 3 years for the firearm enhancement, which is to be served as flat time, in which he would not get credit for time served on, or not credit for time served on, Your Honor, earned early release. I have discussed with him the maximum penalty for both offenses. The standard range on the unlawful possession of a firearm charge is 36 to 48 months. I have discussed that fact with him as well. There are no enhancements in that case. There is no community custody in that case. And so he understands how his standard range is calculated and how his offender score is calculated. Your Honor, I've discussed with him that basically, having reviewed his history, we are stipulating to his criminal history. He understands that and agrees with that. Discussed with him the fact that he will be on probation, and we have discussed the effects of being on probation and what his rights will be or how they will be limited while he is on probation. We discussed that in this case. I asked the court to bear with me. This is a somewhat longer colloquy than I normally do.
You have my full attention.
Thank Thank you. We have discussed with him, or I have discussed with him specifically, the fact that the court will order restitution, or may order restitution in this case, that the court will also order him to pay the crime victim penalty assessment of $500. We've discussed how restitution may be calculated. That will most likely be set by a prior date.
At a later date.
Restitution?
Yes.
State, my understanding is, does not have a restitution amount at this time, that there may be a need for a hearing, and we've discussed the fact that there may be a later hearing.
You said at a prior date, and
Did I say prior date?
Did I do that already? So, okay, go ahead, I'm sorry.
I apologize, Your Honor, I meant later date. That was my mistake.
Go ahead.
Thank you. We have discussed the prosecutor's offer in this case, Your Honor, their recommendation to the court, which is basically for a standard range sentence. The state is going to be arguing for high end. We may argue for low end. We've discussed the fines that the state is going to be seeking in this case, and he understands what the prosecutor is recommending. So we have discussed the law regarding standard range sentences and your requirement to follow a standard range, and the times when you may go beyond or below a standard range. He understands those laws, and I understand that he knows what he's doing in that regard. He is a citizen. We discussed the fact that if he's not a citizen, that it may be grounds for deportation. We've discussed the fact that he may not possess a firearm in any way, shape, or form. We've discussed the fact that he's likely to lose his right to vote, and the fact that he's going to be required to pay the DNA fee for the DNA analysis. We have discussed at some length, Your Honor, the fact that even though he is 17 years old, he is pleading guilty to a strike offense. That strike offense is a manslaughter. Basically, is any felony that has a firearm enhancement on it. And we have discussed that. And he is aware that even though he's 17 years old, he is pleading guilty to a strike offense. A lot of the other paragraphs, Your Honor, that do not apply have been stricken out. He has not initialed those because he has been told by me that they do not apply. The only other two paragraphs that do apply to him is the fact that he is pleading guilty to a firearm enhancement, and the 36 months for that enhancement is flat time, for which you will not get earned early release, and it is also to be served consecutive to the standard range. We've also discussed the fact that because he is pleading guilty to the firearm enhancement and also to the unlawful possession of a firearm, that you may require him to register for the felony firearm offender program. This is the original information, Your Honor. I have typed out a statement in paragraph 11, which he has initialed and adopted as a true statement. And he has then signed this plea agreement. Like I say, we went over it very thoroughly last night. I believe he is making a knowing and voluntary decision to enter into this agreement, Your Honor. And quite honestly, he's pretty much wanted to plead guilty from the get-go. You need to lay in this has been my desire to make sure that he was protected as much as possible. And so he is entering into this plea. I believe it's known and voluntary. I would ask the court to accept the plea.
Thank you, Mr. Tolson. The court has reviewed the declaration for determination of probable cause, and the information probable cause has already been found, but in conjunction with the defendant's statement on plea of guilty, particularly paragraph 11 as referenced by Mr. Tolson, the court will find that there certainly are facts alleged that if proven would support the allegations contained in the information, and the case will go forward on that basis. Good morning, Mr. Brown.
How are you doing, Your Honor?
I'm doing fine. Mr. Brown, there are a few things that I need to explain to you, so if at any time during my explanation you don't understand me, I want you to either ask questions of me or of your lawyer, and I will stop and wait for you to have your questions answered, okay?
I understand.
All right. When you plead guilty to a felony crime, Mr. Brown, there are direct consequences, a period of confinement, fines, other things that may be imposed by the court, and there are what are called collateral consequences, things that happen because of the crime that are not necessarily related to the court's function. You will lose your right to vote. I realize at 17 you don't have the right to vote yet, but you will not obtain your right to vote until you've served any period of incarceration that the court imposes and any period of community custody that follows your release from prison. The only requirement then is that you register to vote, because if you vote without registering, that's a crime. You're also going to lose your right to own or possess firearms. That means you can't live in a house where firearms or ammunition are present. You cannot be in a car where firearms or ammunition are present. You certainly cannot carry those with you on your person, and there is little to no likelihood that right will ever be restored to you. You have to tell me yes or no. You can't just shake your head.
Yes.
All right.
Understand.
Mr. Tolson told me that he went over your statement on plea of guilty with you. Is that correct?
That's correct, Your Honor.
Every paragraph?
Every paragraph.
Every line?
Every line.
Was Mr. Tolson able to answer your questions when you went over that statement?
Yes.
Were you satisfied with his responses to your questions?
Yes, Your Honor.
Do you need any more time to speak with Mr. Tolson before we go ahead with your plea today?
No, Your Honor.
If at any time during the pleading or the proceeding you want to talk to Mr. Tolson, you just let me know. I'll let you do that. Okay? The crime you're proposing to plead guilty to, Mr. Brown, is what's called a strike offense. In the event that you acquire 3 strike offenses at any time during your lifetime, you will be sentenced to a period of confinement for a minimum term of life, which you'll be locked up for life, without the possibility of parole under the Persistent Offender Accountability Act. Unless that law changes, there's nothing that this court or any other court is going to be able to do for you. So you understand that you have a strike offense on your record with this plea.
Yes.
You have the right to remain silent at this hearing. If you choose to go to trial, you would have the right to remain silent, not say anything, not testify at trial. Your silence would never be interpreted as evidence of your guilt. The jury would be instructed that they're not permitted to interpret your silence as evidence of guilt. But when you do a plea, you have to give up your right to remain silent, because I have to talk to you. You understand that?
I understand, Your Honor.
And you're giving up your right to remain silent voluntarily, is that right?
That's right.
All right. If you chose to go to trial on the charges that the state filed against you, you would be entitled to have a jury trial right here in Pierce County. And we would be happy to arrange that. But when you plead guilty, you do not get a jury trial. You understand that?
I understand.
Do you know what a jury trial is?
It's where like 12 citizens come in and they decide if I'm guilty or not.
Good enough. Thank you. If you chose to go to trial on the charges that the state brought against you, your lawyer would have the right to cross-examine witnesses. That means to ask questions of any of the witnesses that the state would bring in to testify against you. You would also have the right to bring in witnesses who might provide favorable testimony for you. Those witnesses would be brought in at no expense to you, and the court would make them come whether they wanted to or not. You understand that you're giving that right?
I understand, Your Honor.
All right, Mr. Brown, in our Constitution there is what's called the presumption of innocence. You are presumed to be innocent of the crimes that the state has charged you with. That means if you did go to trial, you could require the state to prove every element of every crime that they allege you committed, and to prove each element of that crime beyond a reasonable doubt, or you wouldn't be found guilty of the crime charged. When you plead guilty, you give that right up. You understand that?
I understand, Your Honor.
When you plead guilty to a crime, Mr. Brown, you give up certain rights to appeal, to have another court review some of the decisions that I might make, or if you went to trial, some of the decisions that the trial judge might make. Your rights to what we call appellate review or appeal are greatly restricted when you plead guilty. You understand that?
I understand.
Did you go over your appellate rights with Mr. Tolson before your plea today?
I'm not sure. Yes, I do, Your Honor.
So, just to refresh your recollection, Mr. Brown, in the event you plead guilty, then if the court sentences you to a period of incarceration within the standard range, which is a range that the legislature has specified for these particular crimes, then there basically is nothing for you to appeal. Do you understand that to be the case?
Yes, I understand that.
Okay, Mr. Brown, in your statement on plea of guilty, paragraph 11, you state in your own words what it is that you believe makes you guilty of the crime. You have told me in your written statement that on October 20th, 2015, in Pierce County, Washington, my friends AJB and 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 I were walking in the woods out inside the fence of JBLM. We had a gun, and as AND and I were passing the gun back and forth between us, the gun went off, and I shot my friend AND. While in Raymond Hall, I was told that he had died. I have a previous conviction for assault in the second degree, and I knew I was not supposed to be in possession of a firearm. Is that what happened, Mr. Brown?
Yes, Your Honor.
No, it didn't. My children did not know he had a gun.
Guilty. The court
Bullshit.
standard is 46 to 61 months, plus 36 months on top of that, and 18 months of community custody with a maximum term of 10 years in prison and a fine of $20,000. On the other count, the standard range is 36 to 48 months, again with a maximum term of 10 years and a fine of $20,000. Because you will be sentenced to what we call concurrent sentences, the leading offense is the manslaughter offense. So the sentencing range that the court is working with is 46 months to 61 months. Those months of incarceration would be subject to your ability to gain earned early release time. But the 36-month firearm enhancement, another 3 years on top of that, will not be reduced because of good earned early release time, because that's an enhancement. After you're released from custody, however many months it is, you will spend 18 months in community custody. You understand that that's the sentencing range that I'm working with here.
I understand, Your Honor.
And you've gone over that with Mr. Tolson.
Yes, I have.
There may be a recommendation for your sentence, Mr. Brown, made by the state, made by Mr. Tolson, or maybe made by both of them together. I don't know. But I do know this, and you need to understand this. I'm not bound by anybody's recommendation. I can, and I will, do whatever I think the law requires. You understand that?
I understand that, Your Honor.
Has anyone promised you anything in order to persuade you to plead guilty today?
No, Your Honor.
Have you been threatened in any way? Has anyone tried to manipulate you or trick you, twist your arm, somehow coerce you into entering a plea?
No, Your Honor.
Is it fair for the court to understand that the plea you're about to enter is based on your own choice and made of your own free will?
Yes, Your Honor.
All right, Mr. Brown. As to count 1 in the information charging you with the crime of manslaughter in the second degree, and count 2 in the information charging you with the crime of unlawful possession of a firearm in the first degree, what is your plea?
Guilty.
Court will find that Mr. Brown's plea of guilty to counts 1 and 2, as set forth in the information, is a voluntary plea. It's made with a full understanding of the direct and the collateral consequences of the plea. It is not a plea that's induced by promise or threat. On that basis, a plea of guilty to count 1 and 2, as set forth in the information, will be entered, and we'll go ahead with sentencing. Mr. Officer.
Thank you. Good morning, Your Honor. First off, I want to state that Mr. Brown was 17 years old at the time he committed this offense. The state was very deliberate and thoughtful in the charging process of Mr. Brown's case, given the recent developments in the case law with respect to juvenile offenders. A lot of thought went into what to charge Mr. Brown with. And ultimately, I decided, along with Mr. Benton, I believe, who filed the information, that manslaughter in the second degree accurately represented Mr. Brown's conduct should we have gone to trial, there was a likelihood we would amend to manslaughter in the first degree because I think there was a factual basis to support that. But the appropriate charge, given this information that the courts read in the affidavit of probable cause, was to charge Mr. Brown with manslaughter in the second degree with a firearm sensing enhancement. That's what Mr. Brown has taken responsibility for. He, in doing so, stands before the court with an offender score of 5 with respect to count 1. The court knows this. Standard range 46 to 61 months plus 36 months flat time, for a total range of 82 to 97 months. Count 2, an offender score of 4, standard range of 36 to 48 months. In negotiations with Mr. Tolson on behalf of Mr. Brown, it was made clear that if he was willing to accept responsibility as charged in this case, it would be an open recommendation. He could argue for whatever he thought was appropriate. I would argue for whatever I thought was appropriate. And then, of course, Your Honor would do what you think is appropriate. And I will let the court know, I think the victim's family is present. Both. They do wish to speak to the court, and I'll let the court know they disagree with the state's charging decision on this case. I've met with both parents individually, spoken to the victim's mother on the phone before relaying the final offer to Mr. Tolson. They disagree with my decision. I understand that. I think they will express that to the court. I let Mr. Tolson know that so that he was not surprised in what is said in court today. All that being said, I think this is appropriate resolution. I think this fits the facts of this case, and I think the court's aware of Mr. Brown's history, which got him to an offender score of 5 with respect to count 1. That being said, I think the appropriate sentence, given that history, is the high end of the range, and that's what I'm asking the court to impose. I know the court's very familiar. In fact, I've argued before, Your Honor, the recent case law with respect to juvenile offenders, and so I know Your Honor's going to take that into account. I took that into account when we made this charging decision. So with that said, that's the state's recommendation, and I think the court has to impose the standard conditions, 18 months community custody, the standard fines. I'd ask that there be no contact with the victim's family. I don't think that's going to be an issue, but I would ask to delineate that in the order. My understanding is that Mr. Brown wishes to waive his right to be present at a restitution hearing that would be noted in the future. There's been no submission for restitution at this point, and so our office would note that up if and when we receive that information.
Is the state asking for the court to impose any discretionary costs?
No, Your Honor.
Would you like to bring in?
Yes, I think Ms. DeMello would like to speak first.
Right up here, ma'am.
Sorry.
Ma'am, could you tell me your name?
My name is Jamie DeMello. DeMello.
Ms. DeMello, I understand that this has got to be a very difficult day for you. So will you just take your time? It really is.
I do not agree with the charges. I'm sorry. My whole family changed on the 20th. Alex was a young man who all he talked about was which college he wanted to go to, because he was a very good sports person and he wanted to play professional baseball and all that. He always tried to do well. We had been to church together the Sunday before, and he was Adonis's friend. We were neighbors, not friends like that, but he was good to people, not knowing. I'm upset because my boys did not know he had a gun. I still live with his brother, who every morning his brother wakes up to when he can't go to sleep at night because he was there, and his brother was the last person he spoke to. Alex spoke to his brother after he was shot. My daughter and I were the first to the scenes, other since the other boy. My daughter lives with us now too. changed his story how many times he fled. You're talking court cost? I received a bill last week for $360,000 for my son's brain surgery that his insurances won't even cover. That's for one day. One day. My son, I go through a battle every other day because I don't know how he's going to wake up. I do not have the same children I had before this, and I'll never be the same person. This isn't something that in a few years it'll go away. We may learn to manage better. I wish my son could get sent away for 7 years and come back. My son will never walk through my door again. I have a hard time when someone's had a life of a criminal history. My children did not know he had the gun. I wish this would go to trial. They had no clue. And if it was so innocent, why did you flee?
You have to address your comments.
Why did he flee? Yes, I'm angry, but this is not something that's ever going to go away. He was a very loved young man by his school and everyone around him. And it's just sad because he's never going to have the opportunity in life to become the man he wanted. But he will. Through his organ donation, every part of him went to do something. He saved 4 lives. And my son will live on. And he'll carry on his name by doing right things in his life, unlike some people.
You have every right to be angry, and
Our laws have to change.
well, you understand that I'm bound by the law.
I understand that, sir.
And I can only imagine the tidal wave of grief that has been visited on you and your husband and your children.
I do not have, his father, it's not, his father figure, Alex lost his father figure April the 1st. His father has not been in his life over the past 9 years. He has not been active. Alex went through grief. He was still grieving his father figure who passed away April the 1st. All my children were. So on top of losing their father figure, not only did they lose him, now they're dealing with losing their brother. No amount of it won't bring him back.
Well, that's the problem.
No, the problem is when you're giving someone a slap on the wrist, and I'm sorry, it is, for murdering my son. The bottom line is I don't care how the gun went off. My children did not know he had a gun. You weren't supposed to have a firearm. Don't we have laws we're supposed to follow? If you had it concealed and it went off and you brought it, if I'm driving a car and I hit someone's car and they die, I'm held responsible. He brought a gun. It went off. And my son is gone. There's no excuse. There's right and wrong. You shouldn't have had a gun. Bottom line, we're not talking about a toy gun. It was his life. He had his future planned. He had dreams. He had goals.
This is a very tragic situation, and I understand that your children are not as they were before, and you'll never be the same. The effect of the crime is more than one victim. There's always more than one victim to a tragic crime. Sadly, we see another episode here where the flood, tidal wave of guns that are in our society have led us to this terrible, terrible conclusion. I'm very sorry for your loss, man. There's nothing that I can say that's going to take the pain away. It's going to make it any better for you. I will certainly keep your comments in mind as I go forward with the sentencing.
Could I address Adonis real quick?
I'm sorry that we cannot. Sorry. If you have anything else you'd like to say to me, you can go ahead.
I'm good. Thank you.
Thank you for coming in.
Thank you.
Mr. Officer, any questions?
Yes, the victim's father, Michael DeMello, would also like to address the court.
Let it appear, sir.
Morning, Your Honor.
Good morning. Probably not a very good morning for you, sir.
No.
If you could just tell me your full name.
Michael DeMello?
You can all, let me just tell you how sorry I am for your loss. And I'm happy to hear whatever you have to say.
Well, I don't know where to begin other than it was total shock, disbelief. And after being hospitalized, I went to the Lakewood Police Department to get the police reports, and I find tooth picked at it for 6 weeks, and I find a lot of discrepancies, a lot of statements that should have brought a bigger charge, and by witnesses. And the convicted lied numerous times in these police reports, and finally the truth came out. But then again, another lie. I don't know if I can say this, but he had told his friend that he pointed the gun at Alex and pulled the trigger. There was no accident, Your Honor. Yes, he's had a lot of priors, and his parents had pleaded for him previously. Still the same boy. Has no structure in his life, run amok. And I'd like the court to, I don't want to see him come out 25-year-old thinking as a juvenile still, a hardened criminal, and going back to the same. I'd like to see him have counseling in jail, prison, mental evaluation, whatnot, anything to help him. I know it can't be changed, but the future can be changed. And I'd like to see him get the maximum, and that's even being lenient. And I'm still in disbelief. So, well, everyone's hurt by this, and it'll never go away. And one should never lose a child, especially in this kind of circumstance. And it hurts deeply, deeply. I don't know what else to say. So,
I don't mean to interrupt if you're finished.
yes, I'm finished.
Mr. Jamel,
I mean, I could keep going on, but just,
you're right that everyone is hurt by this. And I have no doubt that you've been wounded to your very soul with the loss of your son. And it is a tragic and sad situation. The court doesn't have the kind of pre-sentencing information that I would like to have about the offender. But based on your comments, kids' lives that lack discipline are absent any kind of structure. Someone allowed Mr. Brown to have access to this gun. And the consequences of that combination of circumstances leads us to the tragic and sadly frequent circumstances that we have here. I can only express my condolences for your loss. I'm going to keep your thoughts in mind when I go forward with this, and wish you well, sir.
thank you, Anna.
Okay, Mr. Oster, that ends.
Only one other thing, Your Honor. I calculate Mr. Brown to have been in custody for 81 days, so obviously he would be entitled to credit for those 81 days as well. Other than that, the recommendation is outlined in the statement of defendant on plea of guilt.
I think that calculation should be 129 days. It's custody from
Oh,
October 20th.
that's actually correct. He was in, yep, that's once we charge him as an adult, I'm sorry. Mr.
129,
Tolson.
including the RH.
Yes.
All right. Mr. Tolson.
Your Honor, I have two fears in my life, and only two fears. One is that I will call one day and find myself in the position of the demurrers.
Every parent has that fear.
The other fear I have, and you're right, I think every parent has that fear. The other fear I have is I'm going to get a phone call one day and I'm going to find myself in the position of Adonis's mother. That my son has done something stupid, something he didn't necessarily intend, and has caused harm to a friend. I like to think that I'm a good father. My wife is a mother. And we have worked very, very hard to make sure we never get those calls. We send our son to a good school. We check to see who he hangs out with, who his friends are. Adonis has never had that. With due respect to his mother, he's never had that. Adonis has been in the system pretty much his entire life. You know, his first crime, he was 10 years old when he is by law presumed not capable of committing a crime. And that's the first conviction he has. Your Honor, this was not an intentional act. His mother says they weren't friends, but they were friends. Was he best friends with Alex? No. Was he better friends with Alex's brother? Yes. But the three of the boys were together. It was an accident. You know, this state has insisted, and perhaps rightly, I don't know, I have tried to get them to, with due respect to Mr. Officer, show some compassion towards Adonis, to have him at least, change the enhancement or to dismiss the one count. I guess I'm asking the court compassion in this case. I mean, he is only 17 years old. He is here in adult court by mere operation of the law for no other reason. There was no consideration taken by the system. And I'm not, again, saying the state. I think, truly and honestly, the charges filed are the accurate charges. What my client is pleading guilty to are what he is guilty of. This is not a fault of the state. This is a fault of the system, because the system for certain crimes does not take the defendant into account. They don't take into account development, history. They don't take into account any of the things that we as a society should take into account when we're dealing with children, and Adonis is a child. I am asking the court to impose the low end of the sentence of 46 months. I think that is fair. We are doing the plea when we are doing the plea in the hopes that when he goes to the DOC, because he is still under the age of 18, he should go into the JRA. He should get the benefit of at least 3 years of this sentence.
Till age 21.
Till the age of 21, he should have the benefits of being in the JRA and what programs and services they will have. But when he turns 21, he's going to lose that. And he is, as a young man, going to go into the DOC for whatever the balance of his sentence is. I'm asking the court to make that as small as possible and impose the mandatory for the low end of the standard range of 46 months. Thank you, Your Honor.
Mr. Tolson. Mr. Brown? More than anxious to hear anything that you have to say.
I just want to apologize to Jamie for what happened. And the reason why I fled the scene was just because I was scared, confused, and I was ashamed of myself for what happened. I just didn't know what to do. I just want to really truly apologize for everything. That's not something parents have to go through ever. And I understand my fault and what happened there. It's very horrible. It's like I wake up sweating and crying and stuff, having night terrors about it. Like I've been seeing a counselor at the JRA, but it really doesn't help. It's like something that hurts her. It's something that really truly hurts me too.
Actually, I believe you. That's true. I don't want to cut you off. Is there anything else you'd like to say? Mr. Tolson recounts every parent's, many parents' efforts to work hard to make sure that they never get the call. Unfortunately, these calls come unbidden and certainly unwelcome. It is true, as Mr. Tolson states, lives that lack structure, that are absent of discipline, and that have no positive models to pattern, also lack hope. Behavior then becomes untethered from society's accepted norms and with the consequences that we have here before us today. There is no sentence that is going to make the DeMello's loss any less. There's nothing that anyone on this earth can do that will make this better. The problem is, it only gets worse. It will get worse for the parents who feel that the sentence imposed is not sufficiently harsh. It will be worse for Mr. Brown because serving a period of time in the JRA followed by a period of time in an adult prison has great potential to harden his attitude sometimes simply based on the need to survive in a prison environment. And the court has concern about what kind of person is going to come out of the penitentiary. So there are many goals for peniology. Some goals involve rehabilitation. Some goals involve protection of the public. Some goals involve deterrence of others from committing similar acts. And then there's flat-out punishment. Trying to keep these four concepts in mind, I have to look at an offender's record. And Mr. Brown has multiple felonies preceding this event that should have made him aware that the path he was on, even if he was only 17 years old, was the wrong path. And in particular, when you pick up a gun, for whatever reason, the game changes. So, the judgment of the court will be that within the standard range, Mr. Brown will serve 58 months of imprisonment, followed by 36 months of enhancement and 18 months of community custody. The rest of the judgment and sentence will be as outlined by the state.
Thank you, Your Honor.
Thank you, Mr. Tolson. I'm sure this was challenging.